evening, everybody. Good evening, good evening, and good evening. We are pulling into the new year. We're on the heels of our holidays, and it's been forever since I've been here and spoken with you and shared resource information from our professional partners. And today we are here with Robert Hess from the Robert C. Hess law offices in New Jersey. And we are talking today about the legal foundations for your business. Rob, welcome.
Thank you for having me.
Thank you so much for being here. So a little bit of history about Rob and I. Rob, when did we first meet?
Ooh,
How many?
You're putting me on the spot with this one.
I did, right?
15 years ago? Does that sound about right?
About that, 15, 16 years. And I remember getting Rob's information from my accountant, and I was out on a campsite and I said, I had to call Rob. I was at that point in my business. I need to have that legal support. And Rob was with me and is still with me in things that I even have today. He's put me through a merger and acquisition. He's done a tremendous amount of work for us. So it's my honor for you to be here and sharing some of these experiences with our owners today, Rob. But I'm going to open up with that question. We're going to go into speaking about 3 different areas of business operations and how legal representation is going to be very, very important. Is the startup, operations, and the exit. And the exit can just be that you close. The exit can be that you have a merger and acquisition. But not all attorneys are created equally, right, Rob? So with that question, right, and that thought process, what types of attorneys are there that we should be aware of?
Well, for the business itself, you want to have a corporate or business lawyer. That's someone who's going to help you with the startup, the contracts, day-to-day operational aspects of things. As you move forward in your business, if you have different patents or design processes or things like that, you're going to want to maybe engage a patent or trademark attorney, someone who deals with intellectual property. If you're part of a franchise, you might want an attorney that's going to deal in franchise law.
Right.
And when you get in trouble, you're going to want a litigation attorney to see you through the court battles.
Right. So in those court battles then, Rob, you're my corporate attorney and I have a situation that, maybe a client has, brought me to litigation. Are you saying that I could not come to you, or are you saying that I need to go and find a litigation attorney?
You can definitely start with me. And it's going to be, it depends on, the size of the firm that you engage. Typically, for startups, you're looking more for someone who's going to give you the value added rather than, larger law firms are going to want large retainers to start. And, it may be cost prohibitive to have someone large, start
Right.
representing you from the beginning. Unless you've got a lot of money, you're starting big, then you get a law firm that can handle it all.
Right.
But typically you'd start with an attorney, with your corporate attorney. They'd be able to, at least assess the case and let you know whether or not they can handle it. For example, if it's something small like, a collections matter or something like that, you may not need a litigation attorney. The corporate attorney can handle that for you. If it's something, in the area of like a malpractice or something where you have insurance and slip and fall or things like that, typically at that point, you're going to put in a claim to your insurance carrier, and the insurance carrier will actually engage a litigation counsel to represent you. And at that point, maybe you just have your attorney, on the side, to look over, make sure that, your needs are being protected, rather
Right.
than the insurance company.
Right. And it's part of my coaching with our new owners. And, right from the get-go, get familiar and get an attorney in your team. And I stress this significantly, Rob, and your name is always coming up because when I did go through acquisition and I was sick at the time, I know that you knew me, you knew what my desires were, you knew how to act on my behalf. So it made things so much easier for me. I know that you've been in the hospital, by the hospital bed with documents and so forth. So having that intimate and personal relationship with an attorney, that knows your DNA, that knows the moving parts of your business, I cannot stress enough how for a small business that is so crucial to build on that. And again, Robert, you were there for me through those trying times and through those exciting times. You have always been there. So, Rob, we've used the word lawyer, we've used the word attorney. Now, as much as we know that they're interchangeable words, there is a slight difference. Can you explain that just so that we get some clarity on the differences?
You're not going to get much from me on that one. Lawyer and attorney are pretty much synonymous. You may get differences in jurisdictions. Where I'm from, New Jersey, New York, lawyer, attorney are pretty much the same thing. You go to some other jurisdictions, maybe out in Pennsylvania, Wyoming, or even overseas. The word lawyer may have a more of a connotation of someone that does a general practice, where an attorney is more specialized. But in my neck of the woods, it's pretty much synonymous, or pretty much interchangeable.
Right.
Where you're going to get the difference is what type of attorney, what type of lawyer, are you going to get?
Right. Okay. So let's talk. We're going to go through three different phrases here. Let's talk about startup, let's talk about operations, and let's talk about exit strategy. So explain to us, Rob, the necessities for our business owners who are listening. Some of them have already started, some of them are, in operations. But again, just as a refresher, what are some of those things that are really required as part of your startup?
Well, typically when you start up, you're going to want to form some form of legal entity, whether that's a limited liability company, and a corporation, either an S corporation or a C corporation. You're going to want to choose your legal entity, and that's you bring up the aspect of a team. I think it's really important right from the outset. In addition to an attorney, you also have an accountant, financial advisor, insurance agent, a whole team that's going to be able to get you soup to nuts. Because typically what you're going to have is with, like, for example, an LLC, you're going to file a certificate of formation, or in some cases, in some jurisdictions, it's called articles of organization.
Right.
Depending on where you're at, but some document that's filed with the state that you're located in, that's going to basically tell the world that you're a legal entity, and it's also going to allow you to have some protections. And with legal entities, depending on the type of entity that you choose, there's going to be different legal requirements that you're going to need to adhere to. With a limited liability company, they're a little more lax in as far as the formalities of officers, directors. Is typically run by a member or manager. But in certain cases, where there's more than one of you, if you're just a single sole proprietor, there's no real requirement that you need an operating agreement. But the more members you have, you're going to want to have an operating agreement that is put together, that sets out who has what responsibilities, how you're going to restrict the transfer of shares. You may get into business with your best friend, but you don't want to end up in business with your best friend's, son or daughter.
Right.
So you may want, protections that in the event someone passes away, becomes disabled, that there are restrictions on the transfer of those shares. If you're using an entity like an S corp or C corp, there's more levels to it. You're going to need to have a set of bylaws. If there's more than one of you, you're going to want a shareholders agreement that does that same type of transfer restrictions on how shares get transferred. But you're also going to need to have meeting minutes that put a board of directors in place, officers in place. So there's more requirements. So you're going to want to meet with your attorney to make sure that you have all those obligations in place, so that you don't have any trouble with the entity being disregarded or not formed properly, in which case, the reason you set up an entity to begin with is to limit your liability.
Right.
If you don't do it the right way, you could be subject to liability from outsiders, and basically put your personal assets at risk.
Right.
So
the role of the attorney is to create and ensure the security of, number one, the LLC, right, and number two, the member, right? Mm-hmm. So with that being said, aside from that startup process, how frequent would we want to be incorporating or utilizing our attorney? On an annual basis, a quarterly review basis, or just as and when things occur? What was your recommendation for that?
Well, I would recommend, at least initially, you're going to have certain things, like you're going to start putting agreements together. You're going to, if you have vendors that you deal with, they're going to have their own contracts. You're going to want an attorney to look at those, at least initially. Then once you start seeing the same contracts over and over, you may need the attorney a little less, because, that first time, at least as far as I go, I basically walk you through, tell you where all your pitfalls are. The job of the attorney is not to stand in the way of the business, actually doing business, but more the attorney's there just to basically tell you, here's where your problems are, and if you want, we can add protections in here to minimize your risk and your liability. So, right. For example, a lot of contracts will have an indemnification provision, which means basically, if the client gets sued or the vendor gets sued because of something that you did, you're going to agree to indemnify them, hold them harmless, and pay for basically any settlement, any legal fees, anything associated with that. Okay,
that hold you harmless statement used to throw me every time. And I was like, okay, Yvette, you got to get used to this term, because it's in every agreement that Rob writes up for you.
It's pretty much there. Yes. Yeah.
It's there.
Well, if I'm writing an agreement for you, I'm definitely adding something like that in there to protect
Absolutely.
you from those things.
Absolutely.
So that type of provision, now, you can live with it or you cannot. And if but you got to be honest with you, most people are going to want that provision in there. And, as a startup, you don't have too much leverage. Yeah. So it's really, the job of the attorney to basically
play hardball.
Yeah. It's to basically say, here, this is what your risk is. Here's how we can minimize it, but that risk is still going to be there.
Right.
Another one I like another one I see all the time is, if you're, where they have a jurisdictional clause, which basically says, if you're working with someone out of state, you're, I'll use me as New Jersey mm-hmm. company, but I'm doing a contract with someone who's based in Florida. The Florida contract, the Florida business is going to have a provision that says, Florida law governs.
Right. The New Jersey.
If there's any lawsuit, you got to come down to Florida to fight the lawsuit.
Correct.
Okay, now, again, that's something that it's going to really cause you pause whether or not you're going to want to sue down in Florida, because if you get into the lawsuit, we can go into litigation stuff, but lawsuits get ugly and get expensive. And
Right.
if you have to end up flying down to Florida every time someone takes a deposition, every time you have a hearing, it adds up.
It
So
adds
you
up.
want to try to change the jurisdiction to New Jersey, where I'm based.
Right.
So this way I can fight it here where I'm at home.
Absolutely. And we do have some of our owners who are in multiple states. So, that's a very, very good point in terms of, that language being that, if there is a litigation, where is it going to be fought? Is it in the state in which your company is registered, or is it going to be in the case of the client in which you have the contract with? So let's talk about affordability versus value. Let's be very, very frank here, Rob. From a small business perspective, you mentioned this earlier on, there are some people that may have the fortunate ability to hire a larger firm, more intimate firm. But what are we looking at in terms of, if I hired a Rob, in terms of money versus the value of having that support?
Well, money versus, obviously, I'm going to say everything that an attorney does is going to be value added to the business. But where you're gonna find as a startup, you're gonna pour the money in a little bit more at the beginning. But like I said, once you get used to the contracts and see what's there, maybe you call a little less. So from the standpoint, I charge hourly for these types of services, simply because, as going through the process, you don't know who you have on the other side and how much you're going to, negotiate something, how many, drafts are going to go back and forth. So, right. If it's a quick and easy, I'm going to charge you a lot less, because it's one read through, comments, and you live with what you get back. Like I said, so as a startup, you're going to have less leverage in a lot of the contracts. So, having the attorney, the value added, you're going to want the attorney to read over the contract, give you those comments. This is what I would do, whatnot. From there, you can take it and do it yourself, as far as,
copy, cut, and paste.
These are, take the attorneys out of it. Talk face to face with, with your vendor or your client, and say, look, this is what I can live with. This is what I can't. Let's work it out. And then, you have the attorneys wrap it up, so that way, otherwise, if you have the attorneys doing it, you could get 3-4 drafts going back and forth. And then it's,
right.
I give you a draft, talk to you about it, give it to the other attorney. He talks to his client, comes back with other comments. Now I have to talk with you about those comments, redo the draft, send them back for it. So,
and this is all time that is adding. And again, I go back to the original statement, is that once you have that intimate relationship with your attorney, that gets minimized, because your attorney, although your attorney is still going to make sure he gets your blessing, it gets minimized from a standpoint that you already know the direction that I want to go, right, Rob?
Once I can assess your risk tolerance, once I get to know you, those first couple contracts, I'll be able to assess, like, how risk adverse are you? Are you
right.
willing to just go all in at this point, and just to get the contract, to get started and get moving? If that's the case, as that next contract comes in, it's like, I don't need to go through all of those provisions again.
Right, right. Absolutely.
So it's gonna be more of an upfront cost, and then as you go on, the more your attorney gets to know you, the more you deal with them on specific contracts and things like that. That's when they're going to say, what, like the jurisdiction that we're talking about. It's like, Here it is again. It's Missouri law that's governing it. I know you don't care about it at this point. Just got to bring it to your attention. But instead of having a whole conversation of it,
Right.
it's just here it is. So the time should lessen as you go
As
along.
you go along. These are great thoughts, Rob. I'm going to hold and pause us right there. We're going to be right back, and then we're going to get into those questions, fundamental questions, as it relates to the actual operations. So we're going to be right back. Just hold one moment.
You got it.
We are back, and this evening we are here with Robert Hess from New Jersey, from the law office of Robert C. Hess. Thank you again so much for being here, Rob. It's so appreciated, and we are talking about the legal foundations of your business. We wanted to categorize it into those three different steps, your startup, your operations, and your exit or your merger and acquisition. So I want to touch on very quickly the operational aspect and how that relationship with your attorney works. My first question, we talked about pitfalls, and the question that I have here is that how important is our documentation necessary to hold us through our operations? What is your recommendation in terms of owners starting their business? What documentation should we be holding, maintaining, keeping, updating, reviewing? What would be your recommendations there, Rob?
Well, definitely you're going to want a good set of contracts. Like, for example, with your business, you had the client agreements. You're going to want to have an attorney look at those. You can find stock agreements on LegalZoom or multiple other websites, but I would suggest you really get an attorney to look at it and give you those agreements, at least initially. Same thing with vendor contracts that you have, or if you're manufacturer or a supplier of goods, you're going to have purchase agreements, and vendor agreements again, to get your product. Those type of contracts, you're going to want to make sure that they're really well done, at least initially. Have an attorney get you
Right.
into that proper spot.
Right.
And then really, once you get it set up, at that point, then you really need the attorney for the day-to-day stuff. But as the business expands and grows, and you start earning more, maybe you want to revisit your contracts and see if there's anything that we can tweak or add. Biggest thing I see in contracts, at least from an initial standpoint, as far as payment terms, usually there's pay me on 30 days, and there's no real provision for what happens if I don't get paid. Can I start charging interest? Can I get legal fees? Can I, these type of costs, to do business, are not usually found in those first contracts, because you're just trying to get the client to pay you, right, and you're not worried about what if.
Right.
Yes, but as you go on, you're going to want to say, now that I'm more successful, look, if you don't pay me on 30 days, now there's going to be a late penalty. There's going to be a penalty, 5% of the cost of the bill, sure, or we're going to start charging interest. And then, if we have to bring a collection action, we're going to, we're going to have to charge attorney's fees, and you're going to have to pay those attorney's fees.
And there are the other documentation, the specific and pertaining to the business that is going to save you. For example, HR documentation, right? You are going to always want to make sure that if we have a litigation and it's something relative to an employee, you're going to request that kind of documentation to review, right? So it's important that in any which way that a litigation could be caused, if you had, in dealing in home care, a patient falls, right? And family member says, it was your caregiver, she was negligent, right? Do you have that incident report on file? Because Rob, you're going to need that to comb through as you respond to that litigation.
Definitely. So for example, if you're hiring, employees, you have a staff, you're going to want to make sure you have some sort of an employment manual. There you're going to want, we talk about the different types of lawyers. There are attorneys that just specialize in employment law,
right?
That can, help you with those employee handbooks. You're going to want those employee handbooks passed out. You're going to want documentation saying, I gave them that handbook. And in there are going to be your policies that are spelled out. So when it comes time to terminate someone, that's when you're going to want to give your attorney a call, at least, again, initially. What are the steps I need to take? So for example, in the termination of an employee, you're going to want to make sure that, you've met with them, you've documented, that you met with them. This is what you told them. You haven't done X, Y, and Z. If you don't change, then, you're going to be subject to some sort of, reprimand or termination.
And if you don't have anything in place, you're still opening yourself up for, a litigation to be very easily responded to. Because if you don't have anything, what do you got to stand on?
If you don't have anything, you're in trouble. Because especially these days, someone will find some sort of protected class to basically say you terminated me because of age discrimination, race discrimination, sex discrimination, sexual orientation. The wind blew the wrong way. So they'll find something. So you really want to have those documents together. And I know in practice, oftentimes clients will come to me and say, I got to fire this person.
Right.
And so, well, did you tell them? Have you documented anything? And they're like, well, no. It's like, well, you can't fire them just yet. Okay. You got to meet with them now, document it, give them 2 weeks to change their act, see the error of their ways. If they don't, then you meet with them again, document it. And, and so this way, you're right. You have, when you hand it over to the litigators, now the litigators will say, now I've got exhibit A, I've got exhibit B, I'm good to go.
Absolutely. And I've got Crystal. Crystal is one of our members out in New Mexico, and she just placed up a comment there, and she says, the legal stuff is so scary, but it's needed.
Very true. Well, it doesn't have to be scary.
For new owners, it definitely is. I mean, even though I've been in it some time now, I've learned not to have so much of attention when we come to those kinds of things. But again, it's through learning with you and preparing and being more cautious in what I do, that I don't feel so bad about it. So it does come with time. So let's just say that I got called for litigation, got served some papers, and here I go, have no clue what's going on. Here I've got all of these papers. I am a new startup, Rob. Do I need an attorney to represent me, or can I actually represent myself as the company?
In most jurisdictions, you do need an attorney to represent, at least especially here in New Jersey, New York. If you're an entity, an LLC, a corporation, if you go into court, you must have an attorney. It's just a court rule or statute. So you're going to need an attorney. Quite frankly, you're going to want an attorney. But some litigation you can actually head off before, you may get served with the papers. But, it may be something that, there's just a disagreement as to, a certain, a bill, just taking the most basic, collection action. Someone sues you saying, you haven't paid my bill. And you dispute it because, they didn't provide the service or didn't give you the goods. You may be able to head it off, by having, get yourself an attorney, have the attorney contact the attorney for, the other side and see if you can settle it.
Right.
And the one thing I always say, if you're going to sue for collections, my biggest, tidbit for any new startup, litigation in any form is expensive. So when you have someone that disputes something and you want to sue them, you start the litigation and they come in with an offer of, like that's half the amount. Okay. You really want to sit down and say,
work out that numbers.
Is that half going to cover me, as opposed to me suing and going through litigation? For example, in New Jersey, you have a lawsuit for, wrongful termination of an employee. So they file a complaint. You now have to retain an attorney, answer the complaint. You're going to go through discovery, depositions, interrogatories, which is where they ask you written questions. Discovery, you're going to have to produce documents, and then you're going to go through probably a mediation process or an arbitration process, and then a year or two later, you're going to get to trial.
Right.
Go through
it all
trial.
adds up.
You could end up spending $50,000-$60,000 just on a lawsuit.
Right.
Okay? Whereas, taking the example of a wrongful termination, if you throw some money at them and say, hey, look, I'll give you 3 months severance. You're not entitled to anything, but I'll give you like 3 months severance. Maybe that's, $10,000.
Maybe it's worth it. But a lot of the times is that's that personal principle factor that comes into play, right?
I hate it when anyone says principle, it's a bad thing.
Yes.
You really got to.
Guilty.
I know you are. You've got to really take it and look at it from a business perspective. You got to take that emotion out of it. I know the business is your baby.
Yes.
But when you get hit with that lawsuit, it's like, do you want that baby to starve? Or you take away a meal or two, and then you go on your merry way.
Right.
Because the only ones who end up, this is why I'm not a litigation attorney, because I can say this now. The only ones who end up benefiting from litigation are the attorneys.
Yes, right. And again, guys, we're always going to be very authentic here at Home Care Business Advisors. And as I mentioned, Rob has been with me for many, many years. And yes, he's right. I was that one of saying, well, Rob, it's principle. Right? It's not if it's going to happen to you guys, it's going to be when it happens. It's going to happen. Please make sure that you are taking the preventative measures as opposed to the reactive recourse. I have Carol, who was one of my ladies who just got licensed. Yay. Congratulations to Carol. She's out in Texas. And her question is, Rob, if I'm in Texas, does my attorney actually need to be in Texas?
You should have a Texas attorney because all of the attorneys go through a licensing practice themselves. So your attorney doesn't have to be in Texas, but he needs to be licensed or she needs to be licensed in Texas. So they could have their practice in, say, Oklahoma, but they're licensed to practice in Texas because you're going to want someone who's familiar with Texas law. And, if you're sued or, if there's an issue with, certain Texas rules and regulations, you're going to want someone who actually understands them. I'm admitted to practice in New York and New Jersey. So if I went down to Texas, I can negotiate a contract, in any jurisdiction but to actually know those laws, if it were me, if you say hired me to do your contract work, even after I did the contract, I'd say, now we're going to need to get a Texas attorney to take a look to make sure I'm not missing anything.
Right, absolutely. I also have my Alicia. She's out in Florida. Hey, Alicia. And she says, I use Legal Shield personally. Is it okay to use Legal Shield for business practices, Rob?
I'm not as familiar with Legal Shield. I'm assuming it's like one of those.
It used to be prepaid legal. You remember prepaid legal?
It's not. There's nothing wrong with it.
Right.
It gets you. It's a way to give you a start. Keeps your costs down. You're not going to get. You may not get the highly specialized views of everything, but like I said, it gets you in the door, keeps your costs down, gets you started. Again, at the startup, you don't have a whole lot of money to burn.
Right.
Unless you've hit the lottery and you decided you want to open up, some sort of business. But at that point, it's okay to do something like that. And then as you grow and as you expand, then maybe you want to hire someone more local to you, give you a better perspective, get that relationship. Because, with these prepaid legals, you may not end up getting the same attorney every time.
Correct. So we're going to step over now, Rob, and I hope that answered your question, Alicia. I'm going to step over now into the third phase of business ownership. Again, one of my repetitive statements is we always got to have a plan A, a plan B, and an exit strategy. That exit strategy could be that, you're just going to close and maybe move out of state. It could be that, hey, I do need to close. It's not working for me in this particular market. Or it could be a merger and acquisition. So you might see that term M&A, merger and acquisition. As most of my members know, that I went through a merger acquisition, and Rob, he represented me through the whole process. What, if you can explain to everybody, Rob, what are those fundamental things to prepare for in those latter stages of business operations, whether it be a merger acquisition, whether it be just closing? How does my attorney work with me for that phase?
Well, simply closing and a merger and acquisition are two very different things.
Absolutely.
So, taking the merger and acquisition, from that standpoint, what you're going to want to do is you're going to want to make sure all of your corporate documents are up to date. We went through that process.
Yes.
You didn't have much, as I recall. Actually, most of my clients end up not. I end up having to recreate a lot of corporate documents at that point. But you're going to want to make sure all of your contracts are in order. Everything is in an organized manner. Because what's going to happen is typically if you have a broker or if you get approached by someone, what's going to happen is there's going to be what's known as a letter of intent. Mm-hmm. Sometimes there's an NDA or a non-disclosure agreement or confidentiality agreement that's done ahead of time where the company wants to kind of kick the tires around a little bit. Doing
their due diligence.
Well, the due diligence actually comes a little later. This is more, they want to see some financials to see how much they're going to offer you and whether or not what you're asking is, a fair price.
Right.
And so then you're going to get to a letter of intent stage where they're actually going to give you terms and say, we'll buy you for, X million, it's going to be a 30-day closing. We've got after a due diligence period could be, 30, 45, 90 days. It's a process. And then all of that is going to be subject to actually contracts getting done and set up. So in that merger and acquisition, what you're going to find is you're going to see that they may want you to hang on as an employee for a specific period of time.
Right.
They may want,
which is the worst decision I did, by the way, Rob.
well, yeah.
I never. Yeah, we have to have that discussion because that was the worst thing we wrote in that contract, man.
Well, yeah. Sometimes they want you. Sometimes they want you. You're the face, and they want to keep
Yes.
the face at least for a specific time. What you will have is some sort of a non-compete or non-solicitation type of a period where you can't open up another business because they need to have the ability to compete in the space that you're leaving. So you'll see those general terms in a letter of intent, and then from there, then the contracts are done. Typically, I get involved in the contract phase. I would prefer if I got involved in the letter of intent phase. So you really want to get your attorney involved early because this way we can kind of talk through those things. It's like, do you really want to be an employee, of this company? And if not, then you know what? Let's take that out of the letter of intent.
Right.
So, and then from there, like I said, once you sign that letter of intent, that's pretty much the guts of the agreement. So the contract will get done. There'll be a bunch of legalese associated with it. And then once that's done, then you enter into a due diligence phase where they really come in, check all your books, check all the contracts. If you're leasing the space, check your leases, see how long the lease terms are.
Right. Mm-hmm.
If you own
that was
property.
Grueling.
What's that?
That was grueling when, they came in and
due diligence is grueling,
everything, yes. Down to the water cooler, down to, all of the item numbers of all of the computers. I mean, it was grueling. So again, guys, do it as you're going along, maintain this information, because ultimately you always want to be in that position that you can.
It always depends. It does depend on who's buying it too, because sometimes you will get, those smaller operations that aren't going to be, as, detail oriented in the due diligence. In your case, you had a big guy coming in and, they wanted to see, how many staples you had in the stapler.
Yeah. So I have Miss Carol again. She just asked a question. We're going to wrap up our questions here shortly. And she says, does an LLC have to keep corporate minutes like an S Corp?
No. An LLC is more of it's more like a partnership from the standpoint of how you have to keep your records. So partnerships don't provide you any, legal corporate shield like a corporation or an LLC does. But it's like a partnership from the standpoints of how you have to keep up the business. So you don't have to have annual meeting minutes. You don't have to have, the special meetings every time you want to do something. You may want to just keep, like if you go through financing, and are borrowing money. Typically, the bank's going to want some sort of a resolution from the members of the LLC or from the manager. So you'll have resolutions like that, but it doesn't follow the same formality. That being said, you can have it if you want. So if you're a group of people and you want to have those annual meeting minutes and all those, you certainly can run it that way too. But strictly from a legal standpoint, it doesn't have the same formalities as a corporation.
Thank you, Rob. And like you said, using that just as a general rule of thumb to keep minutes of things that are going on, from a quarterly purpose. And again, in doing what we do in home care, some state licenses are also going to require you to do those types of minutes and meetings anyway. So state level, federal level, but I just say, just do it right across the board. And Crystal has popped up with another question. And she says, if she wants to work with somebody and make a contract agreement with them, example, a massage therapist, how does she determine the proper pay rates and the items or content in the contract?
That's a good question. Something like that, what you're going to do is you're looking more like an independent contractor type of arrangement where they're maintaining their own business. At least that's what it sounds like from the question. They're still maintaining their own business.
Right.
You're just contracting their services. So where to start? I'd start with what are they charging, their customers, and then from there, take a discount. Okay, because you're bringing you're basically
Bringing them the
bread and butter.
business.
Right.
So absolutely.
take an appropriate discount so that when you charge for their services, you charge at their rates, you get that additional profit off of that.
Right.
And then it's really just going to be the back and forth with what you guys are willing to do. That's something that you talk about a lawyer. That's something you can probably leave the lawyer out of. It's really going to be more of what the two of you can agree on. But a good rule of thumb to start is take it from the standpoint of what they're charging, and then discount it based on the fact that they don't have to advertise, the fact that they don't have to use their own facilities or whatnot. Whatever it is, discount off of that. In your head. It may be a good question to ask your accountant is, maybe what kind of an appropriate discount is, and then go from there.
And again, there's going to be some standard things that you always want to have in a contract, as Rob had said earlier, but there's going to be more things specific to the actual agreement or the arrangement that you're having with that, specific contractor or individual. So, put it all on paper, put it all out there, and have an attorney do a last review, most definitely. I have my Michelle Rayner. Hey, Michelle. She says, if an employee does something to a client, for example, steal, is she, as the owner, responsible?
Short answer, yes.
Yes.
The business itself is responsible. Now, you personally are not responsible. If you're in an LLC or a corporation, your personal assets are not, but you are responsible because they're an employee of you. They're your agent. So, general answer, yes. Now, you would have a claim, against the employee to get that money back, but
the likelihood,
you're not going to get that money back.
Yeah, get to the crux of it, Rob.
Yeah.
Right.
But that's where you're gonna want to try to settle before a lawsuit. Basically, if they stole some money, give them a little something. Make them go away. Have them sign a release.
Right. And guys, we all should have a surety bond in place together with our general and professional liability policies. We should have a surety bond, or what they call a dishonesty bond. So it's a level of insurance for those acts of dishonesty that your policy will also, obviously, if after review and analysis, pay out on your behalf. So on the behalf of the business. So always that to consider as well. Rob, we have
also you want to consider if there's insurance that can cover that as well.
Right.
I mean, you got the surety bond, but you may be able to get a policy that would cover that type of theft. That's, again, you talk about team. A good insurance agent is worth their weight in gold, and for something like that.
Your partners, guys, your partners. Rob, we can actually talk for probably another hour. I know that you've treated a lot of our members' interests here, and asking some very valuable and very good questions. But I know that we need to wrap up and let you go and spend some time with your family before your day starts again tomorrow. I'm going to ask this final question, as I always do when we're wrapping up a segment. What would be your final recommendation and your final words of advice to our new owners as they're going into this world of entrepreneurship, business ownership? What will be your last and closing statements to them from a legal perspective?
It's the legal perspective. There's always something legal out there. But what I would say is really get yourself a good team. Get yourself someone, an attorney that you trust. Again, from a startup perspective, you may not have the funds to afford an attorney that charges an hourly rate, you may want to do something like the Legal Shield or whatnot to start. But you really want an attorney a good attorney, a good accountant, good insurance agent, and good financial advisor that's going to be able to help you manage everything, because I don't profess to know everything, and from that point of view, if you get a good team in place, they'll actually, you may think it's like, well, geez, I'm paying this guy, I'm paying that guy, I'm paying this, all over. But if they're all acting together, you're going to find your costs your overhead's actually going to decrease quickly over time.
Absolutely. Well, I know this for sure, Rob, in the last 15, 16, 17 years that we've known each other, you have definitely kept me out of jail. I'm still here to say that you kept me out of jail. So I thank you.
I don't do criminal work, so you can't go to jail.
Well, that's a good thing, because I didn't get there in the first place, right? But I thank you so much for your time this evening and answering and responding to our questions and to our group's questions. So appreciate you. Don't go away. Stay in the broadcast here, but we're going to say good night. And for all of those who have any questions or want to be reached out or want to reach out to Rob, please let me know, and I can connect you guys. That maybe a unofficial conversation can occur of any situation that you guys may be in or want to have more and a further understanding of. Rob, I thank you. Have yourself a great night. Love to the family.
My pleasure. Thank you.
Take care.
Bye.